Okay, in this video, we're going to go over some international issues that are important for technology firms to understand. So, I know you'd like to see more of me in this full screen format, but I'm sorry, I have to head now to the bottom corner. Let's assume that we work for the San Luis Obispo company, Slime. We make tire sealant, and our trademark is, no surprise here, slime. The name and logo allow people to easily find our terrific product, which comes in a bottle and seals tires quickly and effectively. The color of the sealant is green, which also makes it distinctive. To our great dismay, we learn that there's a factory in Thailand that is manufacturing a green gooey substance, and they're putting it in a similar bottle and calling it slime. The product is not nearly as good a tire sealant as ours, but from all outward appearances, it is virtually indistinguishable from our product. To help think about how this might affect us, I want to use this very professionally drawn diagram that depicts the international environment. So, this Thailand-based company sells its slime product in Thailand. But it's worse than that, because it also sells the product to distributors in Thailand, who then export this version of slime to other countries, such as Poland and Ukraine. And then it just keeps going. Some buyers in the Ukraine, for instance, ship it through international channels and it ends up in other countries. And some units even make it to the United States. Let's give it a going this way. There. Here. There. And up here to the United States. The same thing also happens through other international trading routes, like here, this way, this way. You get the idea. In the US, we call these products counterfeits because they display our slime name in a way that makes their product virtually indistinguishable from our sealant here at home. People in this country are buying the Thailand versions by mistake, thinking they come from us, and they are dissatisfied because it does not prevent leaks as they expect. These customers are confused and may become dissatisfied with our brand, believing that our quality control is no good, or that we now sell poorer products. We've also lost sales that we would have made because the customers were confused and essentially tricked. So this is a mess. As an executive for Slime, I might question why Thailand, as a country, would allow this to happen. And before I proceed, I want to emphasize that this is a hypothetical, and I'm going to throw out assumptions that may not reflect the real situation. For instance, for now, I want to assume that Thailand either does not have intellectual property laws, or the laws they have are very weak and nobody pays attention to them. Thus, for all intents and purposes, let's just presume that Thailand does not have laws that protect intellectual property at all. And so, you might wonder, why would a country not have intellectual property laws? I mean, didn't they listen to the last session with Professor Burgunder, where he explained why intellectual property protection is so important for creativity and economic progress? Well, it's true that IP laws do seem naturally beneficial in a number of countries, but it often depends on their economic structure and other matters. So, yes, IP laws are typically seen as a boon to progress in developed economies, such as the United States and Germany. However, other nations have less advanced economic activity, and can't depend so readily on innovations to attract buyers or investors. Thus, it may be advantageous for these nations to allow their companies to freely copy what others have created, and then sell the products at significantly lower prices. In this way, they will attract customers from around the world and bring money into their economies. Hypothetically here, Thailand may be one of these countries that believes it has little to gain from aggressively protecting intellectual property because most significant technological developments are not created at home, but rather by foreigners. Thus, we'll assume that it has decided to not pass meaningful trademark laws. Okay, well, the owner of Slime may then think, I'm going to march into Thailand and sue this factory, which is at the center of these problems, for violating our United States trademark, which gives us exclusive rights to use that name under US trademark laws. So, yeah, we want to haul this guy into a court in Thailand and get that court to prevent further sales because those sales violate US laws. Well, I hope your reaction is, wait, that can't be right. You can't sue somebody in Thailand for violating US laws. Yeah, I understand that they need to comply with Thailand's laws, but should they also be subject to US policies? Think of it this way, and this is just a totally silly and made-up example. Let's assume that you are a woman in the United States and you are walking on the beach in a bikini. All of a sudden, you are interrupted by someone from Thailand who says, "What are you doing? How dare you walk in public without covering your midriff? I'm going to sue you. Don't you know that it's illegal to wear a bikini? The laws of Thailand prohibit it. So put on your shirt right now." Well, that's totally ridiculous, right? But this is really no different than saying we'll go into Thailand and sue a Thailand company for violating a US law in Thailand. Okay, just for grins, let's make things a little more complicated. Suppose you post a picture of yourself in a bikini on your public Instagram account. This photo can be seen anywhere, including in Thailand. Let's suppose somebody in Thailand is offended and so sues you in Thailand for violating Thailand's no midriff law. Can they do that? Well, even if they can, you are probably not going to show up for the trial that is brought in Thailand. So I guess that means you will automatically lose, and then there will be a court order in Thailand for you to pay the offended party some money. Well, what then? Will you have to pay? That's something to think about. Okay, these are some of the problems that arise from the internet, which extends over a world of individual nations. But we think of laws as having only national effect. That is, US law only applies to actions that take place within the physical borders of the United States, while Thailand's laws are confined to behavior that occurs in Thailand. But when we overlay the internet, then it's like everything happens everywhere, and this leads to complications. Let me give you another example. So, not only does slime have a problem in Thailand, but so does, let's say, the rock band Yes. They were recently inducted into the Hall of Fame, and there has been a resurgence of interest in old Yes albums. Based on that, an outfit in Thailand, let's say, presses CDs of a Yes album, and it sells them real cheap for $1. And just as with slime, these physical CD products are shipped via distributors across the globe. And they're even heading into the United States. Well, yes has the same problem as slime under our assumptions here, because Thailand doesn't have any copyright laws. This means that yes can't stop the manufacture and sale of the CDs in Thailand because the CDs just don't violate any Thailand laws. In effect, yes doesn't have a copyright in Thailand, and its US copyright has no legal effect there. So when it comes to the physical CDs, yes has the same issues as does slime with its product. It can't stop the activity in Thailand. Rather, it can only take action in countries where it does enjoy copyright protection. But yes has another problem to address. This is because it is very easy for a person in Thailand to simply upload a copy of the Yes album to a server in Thailand and then make it available to anybody connected to the internet. This means that individuals in the United States can connect to that server in Thailand and download the album to their computer into the United States. Again, Yes might not be able to sue the Thailand uploader in Thailand for violating Thailand's laws, given our assumption that Thailand doesn't extend copyright protection. In fact, what the individual in Thailand did was perfectly legal under local law. But recognize that when a person downloads the album in the United States, the Thailand individual is essentially distributing the album from Thailand to a computer in the United States. But Yes has the exclusive right under US copyright laws to distribute US albums within the United States. So, bang, all of a sudden, the Thailand individual may have uploaded the album legally in Thailand, but violated US copyright law when the US citizen decided to download it there. Does this mean that Yes can sue the Thailand distributor in the United States for violating US copyright laws? Well, we're going to have to explore this a little further, but I'll tell you that the answer is probably, well, yes. But hold on. Even if Yes sues in the United States and wins a big monetary award, will it be able to collect from the individual in Thailand? Can it make this person remove the album from the server in Thailand? Again, we'll have to wait and see on this one. For now, though, I want you to recognize that laws have territorial limits. US laws apply within US borders, and Thailand laws apply within Thailand borders. This works pretty cleanly when physical goods, such as tire sealant or CDs, are manufactured and distributed in the physical world. But things can get a little dicey in cyberspace, where actions and transmissions within and between nations can happen at the push of a button. So, regarding the Yes CD, can Yes sue the Thailand uploader in the United States, or must the case be brought in Thailand? What law applies to this circumstance? Is it Thailand law, where the CD was uploaded, or US law, where it was downloaded? And can Yes enforce a US court ruling when all of the uploader's assets are in Thailand? So, we're going to spend a little time on the first issue, and it's called personal jurisdiction. And the last one, which addresses enforcement. The other issue involves something called choice of law, a topic which we're going to essentially skip in this course. For our purposes, we can assume that the law of the nation where you bring the lawsuit is going to apply to the situation. Okay, I now want to return to the issues facing slime due to the unauthorized products being manufactured and sold in Thailand. One thing that is really troubling is how these products may harm the company in the United States. Fortunately, we have trademark protection in this country, which means that we do have legal rights to prevent sales of the Thailand-based tire sealant within the physical borders of the United States. So, for starters, this means that we can bring legal proceedings against anyone we catch reselling the unauthorized Thailand-based slime merchandise on US soil. If you think about this, the most effective target of these actions would be the importers, where the US sales originate. The problem is that there may be many of these, and so you could end up having to continually locate and sue multiple resellers all around the country. Thus, this is a viable option, certainly one you will want in your arsenal, but let's be clear, this can be expensive and very frustrating. Okay, so I'm back to this diagram again, and so what I was talking about is you could end up having to sue like all of these sellers in the United States. This one, and this one, and this one, and these are mostly these importers here. So you do have rights, trademark rights, against them selling these products, unauthorized products in the United States. And while I'm thinking about this, you would be able to take similar actions in other countries where you have obtained trademark rights under their specific laws. So you might be able to prevent sales in Poland, by suing distributors within that country's borders, this one. Or the same in Germany, like here, or other nations like Japan, where problems develop. The bottom line is that you may have trademark rights in several of these countries, but you could end up chasing people all over the globe just to cope with this initial distribution from this factory in Thailand. As you might suspect, the expenses could add up really quickly. All right, back to our issues, at least in the United States. Besides suing the individual sellers for violating our rights, there are a couple of other tools that could prove useful. The goal with these is actually to stop the infringing items here at the fringe of the country. You don't have to chase all these folks inside, all of these inside, circling and not doing anything, all of these folks in here, because the products will actually never get inside the border if you stop them here. In this regard, the United States has an agency called Customs and Border Protection, or CBP for short, that is responsible for policing goods that enter the country. And so what we need to do is inform CBP that its personnel should look out for the unauthorized slime products and stop their importation at the border. With trademarks and copyrights, there is a mechanism to accomplish this. Essentially, there is a process where you can record registered trademarks and copyrights with CBP. Costs about $200. So we could record slime with CBP, which puts them on notice to look out for offending products bearing that name. Actually, what will probably happen is that you will discover the counterfeit products first and take what you found to CBP. This puts the agency on notice that there's a specific problem with imported slime tire sealants, and they should be on the lookout for these at various ports of entry. If they find them, they will do their own investigation and detain them at the ports or wherever. CBP will notify the importer and allow for a response that somehow explains that the goods are not infringing. And if the explanation is unsatisfactory, the goods then will be seized and possibly destroyed. Okay, so this is one approach, but it's often not enough. First, it only applies to trademarks and copyrights. So this avenue won't help when patents are at issue. Also, CBP will only look for pretty much exact duplicates. So if the works or brand names are similar but not pretty much exactly the same, then you will have to resort to another option. Fortunately, there is another approach which serves to instruct CBP to block goods that violate US patents and more generally infringe copyrights and trademarks. The way to do this is to request a trial-like proceeding before another agency. It's called the International Trade Commission. Remember that if you are addressing a patent issue, this is going to be your only option. And for this reason, most complaints lodged with the ITC involve patent disputes. But it also sometimes is used when materials offend copyrights and trademarks, typically when the infringement is not totally clear. Anyway, you'll have a hearing before an administrative law judge who works for the ITC. The proceeding is usually pretty quick, in the neighborhood of around 18 months. If the administrative law judge then finds that the articles infringe your IP rights, then the judge might issue what's called an exclusion order, which instructs CBP to prevent the articles from entering the United States. The losing side will have an opportunity to appeal the decision, which will be heard by the 5 commissioners who head the whole agency, the International Trade Commission. After that, one could even appeal to a federal court called the Federal Circuit Court of Appeals. There actually is one other feature of the ITC route that almost never arises, but it did make headlines several years ago during the Obama administration. I'm going to get to that actually in a moment. But anyway, the deal with this is that after the ITC issues an exclusion order, the president has an opportunity within 60 days or so to veto that order because he thinks that it's not in the public interest to exclude the imports. Okay, so I want to put some of these things in perspective for a moment. When we talk about litigation, exclusion orders, and the like, what it all really boils down to is leverage. Leverage in a negotiation that ultimately is about how much money a party will be willing to pay to continue operating in a particular fashion. So let's get back to slime for a moment. But for simplicity, I want to change the issue to a patent dispute. Let's say this Thailand manufacturer sells their tire sealant with a different name than ours, not a trademark issue. But we believe that the product violates one of our US patents. When we discover that these products are being sold in the United States, we tell the importers that they must pay a license fee or face lawsuits, patent lawsuits in court. The importers have reviewed the patent and they don't believe that their sealant that they're importing infringes the patent. Anyway, we have a price in mind, but they don't accept it. They believe that if we sue, they're going to win. But you know what? They're willing to pay a low license fee just to make this whole dispute go away. So think about this. We have to chase importers in the United States and then pay attorneys and pay other significant fees over a lengthy period. And in the end, we just might lose. Even if we win, we still may be stuck with those litigation costs. And in the meantime, the importers can continue to sell their products because we haven't won the lawsuit yet. Thus, we face fairly significant risks with litigations, and the importers know this. It's like they hold an ace up their sleeves. But wait! We request a relatively quick hearing before an administrative law judge at the ITC, and the judge issues an exclusion order against all identified tire sealant imports originating from that Thailand source. All of a sudden, the tables have turned because now the importers can't even sell their products in the United States. They also have a strong signal that litigation is probably not going to be successful. Now who holds the big cards? My guess at this juncture is that Slime will have a much easier time persuading the importers to pay an amount far closer to Slime's original negotiation number. So I want you to be aware that there is this option to pursue exclusion orders at the ITC. Here are just a couple proceedings that made headlines in the past several years. Some of you may know that Apple once accused Samsung of violating several of its iPhone patents, which resulted in long-term litigation battles on several fronts across many countries. Anyway, in one skirmish, Apple claimed that Samsung violated certain Apple patents regarding the appearance of the iPhone 4, and also some specific features used in that model. Now, Samsung also holds a lot of US patents. So it used a common strategy that technology firms often employ when they are sued for infringement. The company, Samsung, responded by suing Apple back for violating its own selected patent rights. It's the old, "You're suing me? Well, then I'm suing you back" routine. And so, game on. Among other things, both companies went to the ITC, and each actually got a limited form of exclusion order preventing importation of certain of their competitors' models into the United States. The time period, by the way, was around 2013. Okay, so remember that the president gets an opportunity to review the exclusion orders. And Barack Obama was president at this time. And regarding the order that excluded the Samsung phones, Obama had no objection and the imports were blocked. However, after reviewing the order to exclude specific Apple iPhones, Obama vetoed the ITC's determination and so allowed Apple to continue importing them into the United States. Now, these decisions happened within months of each other, and it struck some observers as a form of local political discrimination against the foreign manufacturer, Samsung. Look, it's hard to deny that politics permeates any decision made in government. But there also were some clear factual differences in these two proceedings that might actually justify the differing treatment. In any event, the set of circumstances certainly alerted the public about these ITC proceedings, which had largely operated under the radar without much widespread attention before this time. All right. Another long-term dispute again involved Apple, but this time Qualcomm was alleging that Apple was involved in a scheme to use Qualcomm semiconductor chips without paying the appropriate fees. It was actually a very complicated dispute, and Qualcomm, it turned out, went to the ITC a couple of times. In the first instance, the administrative law judge at the ITC agreed that Apple infringed at least one of Qualcomm's patent claims. However, very soon after that ruling, a different judge in a different proceeding about a different patent determined that this other Qualcomm patent at issue was invalid and thus sided with Apple. Okay, well, the parties eventually entered a worldwide settlement, putting an end to this incredibly long and difficult, complex dispute. But for a while, the matter was an incredibly public legal mess that it included patent infringement charges, antitrust allegations, had ITC proceedings, US lawsuits, and litigation in other countries. I should also note here that there can actually be risks when you bring an ITC action. For instance, the defendant might persuade the judge in the proceeding that the patent office made a mistake when it granted your patent. Thus, you might end up losing your patent protection in the process. That's what happened to Qualcomm. Anyway, this is something we're going to have to talk about more when we specifically cover patents. I listed one other dispute here, mainly because it was more recent and it involved something other than patents. In this circumstance, BIC brought an ITC action against importers of Chinese lighters, claiming that the products were shaped so much like BIC lighters that US customers were confused about whether BIC made them. This is a kind of trademark claim based on the overall appearance of products, which is sometimes called trade dress. The ITC administrative law judge agreed with BIC and issued the exclusion order. The importers did appeal to the ITC commissioners, and BIC actually won that round as well in 2020. Okay, I want to go back to this incredible diagram for a moment because I want you to start thinking about this international problem in another way. One way to go about this, the one I've been chatting about so far, is to chase people around the globe and try to stop them in as many of the individual countries as you can under their local laws. So we have spent some time on what recourse you might have in the United States to prevent the counterfeit slime tire sealant from confusing US consumers. You can take the same approach in other important nations, such as Germany and Japan. But this is difficult and expensive, and a pretty inefficient way to address the problem. Because the problem originates in Thailand, so if there were some way to shut down the operation in Thailand, this would nip the issue in the bud right at the source. Unfortunately, Thailand's laws allow the Thailand manufacturer to tag its sealant with the word slime. Now, if we could get Thailand to change its laws and enforce them, then perhaps we have a viable way to handle our dilemma in a relatively simple fashion. And so that is the goal of the next two approaches I want to review. We need to find a way to convince the government of Thailand to pass meaningful trademark laws so that we can suitably protect our rights to the slime name in that country. This would allow us to sue the Thailand manufacturer in Thailand and shut down its counterfeiting operation before it becomes a worldwide nightmare. Here's the problem. Thailand probably doesn't want to change its laws. The government thinks its laws are perfectly appropriate and meet the needs of its citizens in the best way possible. Thus, we need to motivate it to see the outcome differently. And we can do this by exercising a stick approach, change your laws or we are going to hurt you in some way, or by offering some carrots. If you change your laws, we will give you these benefits to make it worth your while. So let's begin with the stick. The notion is if you don't change your policies and protect the trademarks of US firms adequately, then we will do things to make you regret it. And the way we're going to make you regret it is by imposing import duties on goods that you want to sell to American consumers. This will make your products more expensive for US customers, so you will sell less of them, and thus your businesses will ultimately make less money. So we hope you realize that your nation would be much better off if you simply changed your trademark laws. This approach is essentially implemented through provisions in a US trade law, specifically Section 301 and its relative Special 301. These laws are administered by an administrative agency in the US government that is specifically designed to handle international trade. It's called the Office of the US Trade Representative, or USTR. Under Special 301, the USTR publishes 3 lists that indicate the degree of disappointment that the US government has regarding the IP policies of specified countries. The message is this: if we get really upset, we're going to start a formal process under Section 301 to specifically investigate identified intellectual property practices. And if you don't begin to change your ways quickly, then we are going to impose trade sanctions or initiate proceedings at the World Trade Organization. At the top is the priority foreign country list, which indicates the countries that the trade agency finds most troublesome. The signal here is that retaliatory trade action is imminent unless changes are made immediately. The USTR also places selected countries in 2 other tiers. Those put on the priority watch list have practices that we find disturbing. The designation here essentially indicates that we may head down the sanctions road if we do not see progress soon. The bottom rung is the watch list, which expresses dissatisfaction, but at a lower level of concern. Okay, the USTR publishes the 3 Special 301 lists annually in the spring, usually around April the 1st. So in 2020, the agency did not identify any nation for priority foreign country status, that top level. In fact, it hasn't fingered a country for imminent trade action in several years. I think the last country to reach this level was the Ukraine in 2013. And that sure raised an interesting international dilemma because soon thereafter, Russia invaded Ukraine. So here we were threatening to impose trade sanctions on the country that we favored in this conflict with Russia. As you might expect, we held off on those sanctions and dropped Ukraine to the priority watch list in the following year. There are several examples of countries that were put on the priority foreign country list in previous years, and some of them did experience sanctions before changing their policies. Some of these nations responded in time to avoid import duties. Instances that I remember include complaints against China, Taiwan, and Indonesia. On the other hand, the US has imposed import duties on a few occasions. For instance, I recall that we did take action against Brazil in the 1990s and Ukraine at the turn of the century. The priority watch list indicates serious concerns and suggests that the US expects meaningful changes soon, or it will investigate whether sanctions are appropriate. In this regard, the US often develops action plans that the countries must fulfill to avoid a formal investigation. Usually, that's enough motivation for the country to make some needed adjustments. However, President Trump put China in the crosshairs in 2017, which did lead to an investigation and the imposition of import duties beginning in 2018. And trust me, China to this day remains a constant source of US antagonism regarding its handling of US intellectual property interests. The bottom rung is the watch list. This is like a preliminary indication of irritation and is a request to take steps before our patience runs thin. I can't recall a circumstance where a watch list country was formally investigated in that same year. Rather, the next move is usually elevation to the priority watch list. All right. Well, that's all I want to note about the Section 301 stick approach to international IP matters. The other way to incentivize intellectual property improvements is by dangling carrots through multilateral agreements, which are intended to offer benefits for countries that adopt internationally recognized standards. What are these benefits? Think of them this way. If you abide by your agreement, then you will enjoy freer trade with our country and all the other treaty members. But if you fall astray, then who knows? For our purposes, we need to pay some attention to two categories of multilateral agreements. One involves treaties that address specific areas of intellectual property. The other is the World Trade Organization. Regarding the intellectual property treaties, we're going to see that there are patent treaties, trademark treaties, and copyright treaties, among others. With all of these, the participating countries have promised to at least meet minimum standards regarding intellectual property protection, or do things in particular ways. So, we'll take a look at some of these later when we address the relevant category of intellectual property. As for now, you don't need to know what the treaties are or what they may entail. There are a couple of things I want to note about these IP treaties. For instance, an underlying principle of most of them is something called national treatment. What this means is that foreigners will be treated the same under local law as local citizens are treated. So, if an inventor from France wants patent protection under US patent laws, he will face the same hurdles to get the patent as a US inventor. He has to meet the same standards, pay the same fees, and will get the same benefits from protection under US law as a US citizen would enjoy. The same is true for US citizens in France. Whatever French citizens get under the French patent law, we get it too. Now, don't be confused. National treatment does not mean that US citizens can go to Thailand and assume they will get the same kinds of patent rights there as they get in the US under US law. Rather, they can only expect to receive the same benefits under Thailand's law as Thailand citizens enjoy. Thus, if Thailand's law is very weak and provides little rights to Thailand's inhabitants, the protection will be equally weak for US interests. What this means is that national treatment by itself does not really help slime address the hypothesized limited trademark protection available in Thailand. Rather, it simply means that Thailand's trademark laws can't be used to discriminate against US citizens and treat them in some way worse than Thailand citizens. Another feature I wanted to note about these treaties is that several of them provide procedural help, which can facilitate and streamline the efforts needed to get protection in several countries. This can be especially vital for companies seeking international patent or trademark rights, and so we'll focus on these treaties later to see how they might help. In addition, some of these international agreements provide that the participating countries have to comply with a few substantive standards regarding protection. For instance, those countries signing the Berne Convention on Copyrights have promised that registration is not required under their laws to obtain copyright protection. So there was a time when you had to register to have a copyright protection in the United States. But this changed when the US joined the Berne Convention in 1988. Okay, we'll get into these a little more when we focus in on patents, copyrights, and trademarks during the course. One problem with all of them, though, is that there is no clear enforcement mechanism to ensure that the participants abide by their promises. It can be like the old playground argument. You promised! No, I didn't. Yes, you did. Look here, and everybody knows it. Well, maybe I did, but what are you going to do about it? You might think we could take the faltering country to some international court that could make them somehow pay for breaking their agreement. But it just doesn't work that way. So, at the end of the day, these agreements may lack teeth when push comes to shove. Nonetheless, they do set important guideposts of international cooperation, and most participating countries do try to comply. Having said that, there is a crucial international framework for trade that incorporates a mechanism for participating countries to enforce associated trade agreements. I'm talking about the World Trade Organization, which is an international governmental body that oversees a set of multilateral agreements dealing with a host of matters, such as tariffs, agricultural policies, access to services, and most importantly for this course, intellectual property. Last I checked, the World Trade Organization, or WTO, has 164 members that have pledged to abide by all of the associated agreements. I can't overemphasize what a huge deal it was when China entered the organization in 2001, and likewise when Russia joined in 2012. This now means that for all intents and purposes, every important trading nation is now a member of the WTO. All right, a couple of basic elements regarding the operation of the WTO. One overriding long-term goal is to facilitate free trade among the members by encouraging rounds of tariff concessions and the reduction of other trade barriers. Another fundamental principle here, as with the IP treaties, is the promise to afford national treatment to all the other members. So each participant has agreed to treat foreigners the same under their laws as their own citizens. Thus, the WTO members have agreed that they will typically not discriminate against foreign citizens under their laws. Related to the principle of non-discrimination is a pledge to grant all the other participants what is called most favored nation status. In the United States, by the way, we refer to it as permanent normal trade relation status, but it means the same thing. All right, listen up. This is not what you might think at first blush. Most favored nation does not mean that I'm somehow going to be treated better than everyone else, that I'm going to be the favorite or something like that. Rather, what most favored nation status means is that every nation is treated the same as the country that has the best deal. In other words, if the United States, for instance, were to give a benefit, let's say a lower tariff rate, to one country, then it has to give that same benefit to all the others. In other words, what we give to one, we have to give to all. And in this way, we again are bound to not discriminate. Saying this another way, we also promise that we won't single out a country and treat it worse than the others. Okay, so I now want you to think how our pledge to grant WTO members most favored nation status may affect the implementation of our Section 301 tariff stick. Remember how this process works. We put a country, let's say China, on one of the priority lists, and then we do an investigation and decide we want to put on trade sanctions. But if we unilaterally do that, then China will be paying a higher tariff rate than other countries, which means we are no longer treating it as a most favored nation. And thus, by imposing the sanctions, we simultaneously break our promises at the WTO. All right, so I mentioned that one of the agreements administered by the WTO deals with intellectual property. The agreement is titled Trade-Related Aspects of Intellectual Property Rights, and it's known by the acronym TRIPS. TRIPS provides minimum standards that all nations must adopt to protect intellectual property, and it includes requirements regarding patents, copyrights, trademarks, and trade secrets. The WTO nations have also promised through TRIPS to have legal mechanisms in place that allow those enjoying the IP rights to enforce those privileges against violators. So let's get back to Slime's problem in Thailand with a factory that manufactures tire sealant using its name. Since Thailand is a member of the WTO, this means that the country must have trademark laws that would allow the US company to obtain trademark rights for the word slime in Thailand. It also means that if we successfully acquire those trademark rights, then there must be a way for us to meaningfully enforce them in the country. In other words, if the Thailand factory is violating our trademark rights by calling their product slime, then we should be able to sue in Thailand court and get an order preventing further infringement and compensation for what we may have lost. At the moment, I don't really care that you know the specific details in TRIPS. Just be aware that its adoption was a significant achievement for countries such as the United States, and that it definitely has proven helpful to US technology firms trying to navigate troublesome international waters. However, there are still enormous holes. Many times, countries don't pass the laws that we think are required by TRIPS, or more likely, they make it difficult to enforce what's on the books. This means that businesses still have to be constantly on their guard. Also, there will be times when the United States or other WTO nations become fed up with recalcitrant nations. Fortunately, the WTO has a formal mechanism for these countries to complain and has a process that can be used to ultimately motivate compliance. Here, in a nutshell, is how this enforcement process works. Let's assume that Thailand does not meet its obligations under TRIPS with regard to its trademark laws and enforcement. This has led to significant problems for companies such as Slime. If the United States becomes sufficiently upset, then it can file a complaint with the WTO. Why does the US become upset? Likely because companies such as Slime approached key players in the US government and explained how they are being harmed by activities in Thailand. We're talking about the president, the USTR, and/or members of Congress. You get the idea. Through political connections and persuasion, the companies convinced the US government that filing a WTO complaint about Thailand is warranted. So, Slime doesn't file the complaint with the WTO, rather the United States does so. The goal of this complaint is to demonstrate that Thailand is not fulfilling its obligations under TRIPS and other WTO agreements. And what the US ultimately seeks with this complaint is permission to no longer treat Thailand with most favored nation status until Thailand makes appropriate changes in its laws and with enforcement. In that event, the United States would be able to legitimately impose trade sanctions on Thailand, even though the US would be treating Thailand worse than other member nations. The WTO ruling would also open the door for other countries to perhaps do the same thing. So here's a snapshot of how this would proceed at the WTO. The US files the complaint about Thailand's trademark laws with the Dispute Resolution Body, or DSB, at the WTO. The DSB has one representative from each of the member nations. The DSB will first arrange for the parties to enter consultations and attempt to work out their differences. The hope is to settle the dispute before resorting to formal proceedings. If consultations fail, then the DSB will initiate a hearing before a panel of judges. They will review the evidence and decide whether the United States is correct that Thailand has not been meeting its WTO obligations. The losing party, let's say Thailand, then can appeal the ruling to the appellate body, which reviews the panel decision. If the appellate body also agrees with the United States, it will then forward the decision to the dispute settlement body. The DSB will then adopt the ruling unless all the DSB members unanimously vote to reject it. After that, the losing party often relents. But if it doesn't, then the DSB may authorize import duties. So here, the end result would be that WTO would allow the US to suspend most favored nation status with Thailand and impose a designated level of sanctions. So I believe that around 600 complaints have been filed with the DSB since 1995, and slightly over half of these have resulted in panel decisions. I may have assigned some reading that discussed several examples of contentious proceedings. I've also noted a few of these on the PowerPoint slide. Not that I really want you to remember them, but just to bring them to your immediate attention. I also want you to notice that it's not only countries such as Thailand and Indonesia that appear on the list. Sometimes we see major industrial nations, like the European Union and the United States, going after each other. The US, for instance, has brought complaints against the EU for blocking imports of bioengineered crops and cattle treated with bovine growth hormones. In addition, each of these parties has filed complaints regarding subsidies to the airline industry. The latest that I recall was a complaint lodged against the EU for subsidies to Airbus, which I believe the United States won. The United States has also brought several complaints to the World Trade Organization against China, alleging that China has not complied with TRIPS or other agreements that are monitored by the World Trade Organization. The panels have agreed with the United States some of the times, but not always. And this is an important observation. We sometimes naively think that the US has the moral high ground and is necessarily right, but the WTO does not always agree with our position. For instance, Mexico and Canada complained about a US law that required beef to indicate the country of origin. I think the legislation was a response to mad cow issues, but the countries argued that the law served to discriminate against the sale of their products in the United States. Anyway, they were successful, and the ruling motivated the US to revise the policy. Oh, and here's an interesting one. The islands of Antigua and Barbuda, which house online gambling operations, complained to the WTO about US laws prohibiting their activities, those gambling activities, within US borders. The islands argued that the US was wrongfully discriminating against them because the United States allowed online betting on horse racing. And you know what? Antigua and Barbuda won. The more interesting aspect was the "so what are you going to do about it" part. You see, the WTO did give the islands permission to retaliate against the US with import duties. And remember that import duties are intended to make the US feel enough pain to change its laws. But of course, the United States doesn't export all that much to Antigua and Barbuda. So the ruling was kind of a hollow victory because the remedy was too small to change US behavior. Critics have used this case to highlight a flaw in the WTO system because it may not adequately serve the interests of the small nations. Oh, I thought some of you might have particular interest in this last item, which has to do with cigarette packaging. The issue here is a law in Australia that requires cigarettes to be sold with plain packaging, which merely indicates the name of the product and health warnings without flashy trademarks or other promotional text. The intent is to reduce the appeal of cigarettes and make the health warnings relatively more prominent and effective. Anyway, several nations complained, arguing that the policy violated TRIPS as well as other WTO agreements regarding trade barriers. I should mention here that the WTO does provide exceptions for restrictions justified by health concerns. And based on that, Australia has been successful in defending the law to date. Okay, there's one last thing that I just want to very briefly mention because as we go through the course, we may encounter laws and policies implemented by the European Union. Now that the United Kingdom has left the EU, 27 members remain. For our purposes, think of the EU as a transnational governmental structure in Europe. You know, in the United States, we have 50 separate state governments, and then a federal government that spans over all of them. The EU is kind of like the federal government, while the 27 countries are like our states with our own individual governments. I don't really want to go into the operations and powers of the EU, or how its various governmental bodies pass and implement laws. We have an international law course that does this, if you're interested. I just want you to be aware of a little vocabulary here. In particular, the EU passes two distinct types of laws. One is called a directive. A directive is an instruction to all of the 27 member countries, telling them that each needs to pass laws through their own national governments that meet specified guiding principles. Thus, the nations can pass laws with different terms, but they all must meet the same objective. A regulation is simply a law that is applied across the EU. It's somewhat like a federal law in the United States. Thus, the terms will be the same in every country within the European Union. I think this is a good place to stop. I want to next explore a few procedural matters, such as where one can bring lawsuits, something called personal jurisdiction or venue. We also will think about some issues that arise when trying to collect the money. Have a good one.